welcome to Nexus Extra. This week we have with us the New York defense lawyer, former prosecutor, Vinoo Varghese. He has recently had an article published in the New York Law Journal entitled along the lines of, "If we are to get justice for George Floyd, we have to ensure a fair trial for Derek Chauvin." Vinoo, thank you for contributing to Nexus Extra this week. What exactly are you arguing in your article?
Just basically what the title says, and there's an extended version of the title, which is it must recognize Keith Ellison's abuse of prosecutorial discretion. I'll explain what that is. In essence, people are demanding, worldwide, George Floyd has become this person, this hero, this martyr. It's a lot more complicated than that, and there's a lot more to this video that initially meets the eye. The thing here, though, and this is what's most important, is that Derek Chauvin received a fair trial. That may sound like blasphemy to people who are calling for blood, but if the American system is going to get things right, they have to make sure that people like Derek Chauvin, who are vilified and hated, receive a fair trial, because that's in essence what America is built on, and that's why we split from you guys over there in London, back at the time of the Revolutionary Wars, to make sure that people got fair trials. And particularly here, what's happened with the charging of Derek Chauvin is really disturbing. The charge that was initially put forward, there were two charges: murder in the third degree and manslaughter in the second degree. Manslaughter is a viable charge. It basically says that he created or ignored a risk that could have led to death. That seems a very prosecutable charge based on the video and the fact that George Floyd was pleading for help, saying he can't breathe. The initial charge of murder in the third degree says that it was a depraved indifference, meaning that he was of such an evil mind that he caused the death of someone. That's a problem charge, because this was a lawful, not an unlawful, but a lawful legal arrest. George Floyd was identified as a perpetrator of a crime. George Floyd then resisted arrest. He refused to come out of his car. You see a struggle there. And then when he was in the car, he was struggling with officers, and that's when they put him out onto the street.
Are you saying that evidence? Are you saying that that is shown in video evidence that we are yet to see?
No, that's been released. The Washington Post and the New York Times have received additional videos that they've gotten from the streets, and they've put this on their website, and they show the viewpoint from various, so it's basically 3 or 4 different videos they've put together. And so you see Floyd struggling with the initial set of officers refusing to come out of his car. Then you see him handcuffed, taken over to the police car, put in, and then he's struggling with officers there, and that's when they pull him out and put him down on the ground. The hold that everybody talks about, having the knee on the neck, guess what? That's allowed per police procedure in Minnesota and in most places in this country. It's only after Floyd's death of the Minnesota City Council or Minneapolis City Council moved to ban this. So,
but Vinoo, while it is allowed as a restraint, surely if the officer continues that hold for so long that the suspect dies, you now start to look at criminal charges.
Possibly. And that's why I said that the manslaughter charge is a viable charge. I mean, he's out there for 8 or 9 minutes. People are yelling at him. Now, in his defense, this is a chaotic scene. And the other thing that people don't want to talk about, in fact, it was papers on your side of the Atlantic, Matthew, that have published this stuff, because you're not seeing it in American papers. But you're seeing the fact that George Floyd had a violent criminal history. He spent 5 years in a Texas prison for a home invasion with the gun of a pregnant woman. Now, another twist to this is that Chauvin knew Floyd from their gig together at a Minneapolis nightclub. Well, you have to presume that Chauvin knew about Floyd's violent history. Floyd is also a very tall man, 6'7" in American terms. I don't know what it is in meters and stuff. But meters, yeah. He was a very tall guy. So when you look at that, you have a situation where all of this has to be taken into consideration. Now, when I mentioned Keith Ellison, that's the Minnesota Attorney General, former congressman. He came in, he was appointed by the governor, and then he upcharged. There's a practice called charge stacking in the United States where prosecutors throw on a bunch of stuff to scare somebody into pleading guilty. The charge that he put on is something that's just, it's impossible to prove and not appropriate for the situation. So when you're
saying that the charge of manslaughter is something that you would feel comfortable with, but the charges of second and third degree murder, you consider those charge stacking, a tactic to intimidate Derek Chauvin into accepting the charge of manslaughter, into admitting the charge of manslaughter.
100%. And these are two charges based on the statutes, and I review the statutes carefully, that are not provable based on the facts. Manslaughter is a legitimate charge. Of course, Chauvin can still fight that. But why this is important, because you're looking at something where he could face 10 years in jail for manslaughter versus 40 years in jail for second-degree murder. And what happens, and this is a common practice of prosecutors all across this country, both state and federal, state everywhere and federal prosecutors across this country, is that they stack on charges knowing that the fear of going to trial is that there would be a huge fear of going to trial, and it's what's called a trial penalty, that, wow, you know, you could get convicted of something much higher when they're offering you a deal to something lower. And I think that this is something, when you talk about reform, this is where the system needs to be reformed to prevent prosecutors from doing this.
You also say in your article, it's not just a legal technique or strategy to intimidate the defendant, but the charge stacking was as a result of public pressure. What do you tell us about that?
So in this particular case, I mean, you know, when you talk about justice for George Floyd, you have to compare this case to other cases where people were not charged, right? Officers were not charged. So you had the Ferguson riots a few years ago with Michael Brown. That officer was not charged. The big case that came out of New York several years ago, which got worldwide attention, was the Eric Garner case, where you saw that Eric Garner was a large, heavy man, black man, who was brought down in a chokehold by Officer Daniel Pantaleo. Pantaleo was never charged. The state did look at grand jury, presenting a case to the grand jury, but the grand jury did not charge him criminally. Then the feds did not charge him, and these are the feds under Obama, by the way, not under Trump. So this is important to note. Pantaleo, the officer who violently, I mean, that was an incredibly violent maneuver. You saw him grab him from the back, bring him down, choke, and you hear this man saying, "I can't breathe." Anybody at that point should have pulled off Pantaleo. Any one of his fellow officers should have done that. That didn't happen. So what you have that Pantaleo was never charged. He continued to be an NYPD officer for 5 years, and was only fired last year. Chauvin was arrested basically the next day. He was fired immediately. He and his colleagues were all fired immediately, and he was charged the next day. What happened is that Keith Ellison comes in, and I think at the behest of the governor of Minnesota, to say, you know what, this isn't enough. Let's up the charges here. Ellison admitted in his press conference that this is going to be hard to prove. And Ellison is a former criminal defense attorney, but not a prosecutor. You know, I'm both. I am a former prosecutor. And he says, well, this is going to be hard. There's only been one case where a police officer was charged with murder and was convicted in Minnesota. So if you know all of this and you know that these aren't viable charges, they know these aren't viable charges. This is something that's there to placate the public, to say, hey, we're doing everything we can against this guy. But in essence, what they're doing is undermining the very criminal justice system that they're sworn to uphold, because, again, Chauvin deserves a fair trial.
Another one of our regular guests, who is a trial lawyer, Titus Nichols, who's also African-American, has read your article, and he's totally dismissed your concerns, because he said that, generally speaking, white policemen are given the benefit of the doubt, and that to be concerned about them getting a fair trial is absurd.
Well, then he's clearly not a criminal defense lawyer who's sworn to uphold the Constitution, because it's not about police officers, it's about everyone. So if you want to be concerned about the system needs to be fixed. The system needs to handle and discipline prosecutors who overcharge. This is something they do to black men all across this country, right? So he should be concerned about that, and there shouldn't be a separate set of laws for somebody because he's white and he's a police officer. There's an article that came out in the Wall Street Journal last week called "The Myth of Systemic Police Racism." And it showed that there are more white people shot per encounters with police than black people in this country. And when you look at it, and that if you're a police officer, you're more likely to be killed than a black man facing the police. So then when you take a look at all of that, and you look at these numbers, which are been backed up by studies in the Washington Post and in the FBI crime statistics, well, you have to ask yourself, what's really going on here? And would these riots have been so violent if people in America hadn't been shut down for 3 months? I mean, this was an opportunity. I had been predicting that there was going to be riots, and there needed to be something. There was going to be something like a George Floyd that set everything out in motion. So you look at some of the people that are doing things. You have in New York, you have a woman named Shauna Shader, a 27-year-old white woman, who threw a Molotov cocktail into a police car filled with 4 NYPD officers. A white woman, was she oppressed? I mean, was she oppressed by the police? I mean, it's interesting. Probably not, but she's been arrested as an agitator all around the country. Now she's facing life in prison. 2 lawyers here in New York also threw a Molotov cocktail. A Pakistani-American woman and a Jamaican-American man, both corporate attorneys. Well, one worked in a legal services organization, one worked at a large corporate law firm. They went out and lit a police car on fire. I mean, why? Were they, so oppressed? I mean, here's the thing that people have to understand. If you're not involved with the criminal justice system, then you're making a lot of speculation. You're making a lot of assumptions about things. And so when you take a look at George Floyd, compare that to Eric Garner and the police officer in Eric Garner, or the person in Ferguson. I mean, the criminal justice system has come a long way, and unfortunately, with Allison and his charge stacking, it's gone too far. And now you've seen the ugly other end of this.
Let me ask you one final question, Vinoo. The police do enjoy a certain immunity from prosecution. Can you describe what that is, and do you think it's likely to be removed from them as a result of the killing of George Floyd?
Well, there's no immunity from prosecution for police officers. What there is what's called a civil doctrine called qualified immunity, which the Supreme Court just said yesterday they're not going to review. So if you want to end qualified immunity in federal cases, then you can do that. Senator Rand Paul has put forth a bill to try to do that. That can be done by Congress to prevent this, which is basically saying that there is a certain set of immunity which their actions will not be scrutinized. It's a little more complicated than that, but it's about the simplest way of putting it, to prevent them from a civil suit. And then the state or the city will then indemnify these officers. But there is no bar to criminal prosecution for a police officer. And particularly in George Floyd's case, what Minnesota has done, what the charge stacking and Ellison has done, is basically say that a police officer effecting a lawful arrest is going to be charged with murder. I can understand the manslaughter charge based on the circumstances around it. And then even then it's questionable, because when you look at the totality of the circumstances, he could be cleared of manslaughter. But at least that's a reasonable charge in light of the videos that have come out.
Well,
the other two aren't.
We will have to wait for the trial and for the judge to make their determination. In the meantime, Vinoo Varghese, thank you for your perspective and for contributing to Nexus Extra. And thank you at home and on your phones for watching. Goodbye. Well, thanks for watching our program. If you liked it, please give it a thumbs up, share it with your friends and family, and even subscribe.